everyone, this is Maciel, and with me I have my partner Jordan Schwartz. Thanks for joining our webinar today on wage and hour issues during the COVID-19 pandemic. This is the 11th regularly scheduled webinar in our 2020 Labor and Employment webinar series. So the things we're going to cover today are really three main points, right? I'm going to start out and talk about some pandemic pay issues, nothing too unique under the FLSA, but the way that the pandemic is making these long-standing rules, nuanced and novel in a new and different way. So we'll talk about some of those. Jordan's going to talk about some new Department of Labor regulations that are coming out or have come out in 2020 and the impact of those. And then we'll close with some wage and hour issues that we anticipate under a potential Biden administration. No making any predictions here, but in the event that the Biden administration does receive enough electoral votes, then what can we anticipate with the Department of Labor under a Democrat? So let's start with the pandemic pay issues. So the first thing to talk about is most companies, and probably many of you on the line, are continuing to allow your employees a choice to continue teleworking. They could be working, from their home. They may have relocated elsewhere to ride out this pandemic and are working in different states. I've heard of some people even, relocating internationally. But in any way, you want to make sure that the rise in telework, we believe, will likely result in a rise in wage and hour claims. Over the last several months, we've seen thousands of new claims being filed against employers. I will say that for the most part, the ones that are driving right now the rise in litigation relates to retaliation for complaining about worker safety or other issues. We're seeing a rise in not allowing employees to take leave of absence under the FFCRA and other kind of discrimination related claims. But I would expect the plaintiff's bar is very aggressive on wage and hour, and I wouldn't be surprised that because there's a 3-year statute of limitations, at least federal law, longer in other states, that we may start to see some of these claims percolate in 2021 because of the way that you are paying your workers. And as hopefully everybody on the call knows, you have to pay your non-salaried workers, your hourly non-exempt workers, a minimum wage, and then overtime pay for any hours over 40 under FLSA, and then maybe different in other states. And so what you want to think about is, have you acclimated to be able to properly, track and record and report and supervise your non-exempt workers' hours, because you don't see them on a day-to-day basis, right? You don't know when they're taking breaks. You don't know when they're leaving their computer. You might have a lot of employees that are working intermittently throughout the day because of remote childcare, the virtual learning experiences, or to care for people in their household that are young or old or have health conditions. So you might not have someone working a straight 9 to 5 day anymore for an hour lunch, which was typical in the past. So think through, how are you tracking your non-exempt hours? And if you're in a state that you are required to have a paid lunch or paid meals, how are you making sure that those employees are tracking that? Just as in DC, this is where we're located. DC law requires employees to log in, when they started their shift, when they left their shift for a break, when they came back, and their end of the day. And so making sure that continues to happen even in this remote work environment. And then you want to make sure, this is a typo, but employees could claim that they were shorted work hours if they were working, longer into the day or into the evening. Again, could be that they're working more than the hours that they worked previously, and therefore there are more overtime hours that are available to them. So one of the things we really recommend is, if you are allowing your employees to telework, make sure you have a robust telework policy. Hopefully we are many months into this pandemic, and hopefully many of you do have a telework policy, but take a fresh look at it and make sure from a wage and hour perspective, you are covering your basis for payment issues, so that it's clear which positions are eligible for telework If you have non-exempt employees that are eligible for telework, you want to specify that. You specify for those employees, when are they expected to work, which days, how many days, what are the expected work hours, particularly if it's intermittent. Like I said earlier, maybe you expect them to work a 7.5 or 8 hour day, but they could spread it over, a 12-hour day. But those work hours should be recorded as working, whereas the other hours are not. You also want to make sure that you have a really good policy in your handbook about reporting of hours worked, and that if they apply for overtime, that is, approved by a supervisor. Obviously, if someone has unapproved overtime, you still have to pay them, but that can be a performance issue. You want to make sure your overtime policy is clear, that people cannot work unapproved overtime without a supervisor's knowledge. And then when they get their paycheck, or you're looking at, their timesheet at the end of the week or the end of 2-week pay period, that they acknowledge that, yes, this is an accurate reporting of my hours. And when I receive my paycheck, yes, this is an accurate number of hours, and I acknowledge that I haven't worked any hours that have not been reported. That's another good defense to any claim that they overworked and that your managers knew about it. If you have an acknowledgement by the employee that by submitting these hours of work, the employee consents and acknowledges that these hours are accurate. That's even true for people overestimating their hours. That's a good reason for falsification of time records if you have that acknowledgement. And then the other thing to think about is reimbursement issues. Generally, the FLSA only requires you to reimburse workers when certain expenses that are necessary push their pay below minimum wage. But in this era of telework, we've got everybody working from home. And so do you have in your telework policy any specifications of how that home office is going to be set up? Do you require your employees to have their own computer, or have you provided a company computer? Do you require them to have sufficient internet access in order to be available, at normal business hours? Do you require them to have a cell phone, or is it a company provided cell phone? What about a printer and office paper and ink and all the other attendant things that normally you order for supplies at your office, but now you expect your employees to have as well? So there's no, as I said, no federal law that requires. Different states may have their own business reimbursement policies, so check the state or local law. But also consider too whether you want to have a stipend for employees to make sure that their home office is as comfortable as possible, that they might choose to spend their money on a monitor or a really good chair. And that can go a long way for employee morale, to make sure that they are able to be as productive as possible in their home environment, like they would be at the office. And even while maybe not necessarily something required, it could be a reimbursement could go a long way towards employee morale and an incentive to let them know that you're really thinking about them and making sure that they're working in a safe and comfortable environment. Another interesting nuance to remote workers is commuter time. So typically you're not required to pay for your employees to commute back and forth to work, but if a time traveled is not necessarily part of a regular commute, that rule may not apply. So sometimes that applies if you've got non-exempt workers that are flying to a convention, for example, and is that flying time, compensable, or, the work time when they're away from the office, or you've got, a meeting several hours away and they're going to be on the highway, is that considered compensable time? What we're thinking about too is now we're moving to widespread remote work. And if you've got someone who now's primary location is their home, which we're starting to see that shift, and that has a lot of attendant other issues. If their primary work location is at home and they need to travel to go to the office maybe once a week or once a month, and they're non-exempt, that might be entitled to compensation as travel time. So be mindful as you're supervising your non-exempt employees who have gone back to working from home, when you ask them to come into the office, how long is their commute, and is that something that might have to be compensable? The other issue we're starting to see is as companies are starting to come back to work, right, reopen and asking more of their employees to come back to work once a week or 2 days a week or more frequently if you've been closed up till now, we've got, you know, social distancing mandates, and those social distancing mandates could create some wage issues. You know, my office alone, you walk into my office and the building has different aisles, and I can only access elevators with 2 at a time. And so people may have to wait in the lobby as they get into the elevator. That could create lines. You might spend more time waiting before even getting into the workspace where you would technically start the clock. Some of that may be de minimis. It really is going to change based on the nature of your business, but think about whether those kind of social distancing mandates creates an issue of compensable time. And then if you think about staggering your shifts, some people may say, okay, we're going to have this team come in on these days of the week, or we want, you know, people to work 4 days a week or at different start times. Same kind of thing. Be very mindful about making sure that people are recording the time that they're working and when they come in, so that we're not inadvertently potentially running into some overtime and other compensable wage issues. One of the questions we get a lot at is, what happens for health screens? I want to be able to take the temperature of my employees as they come into work. I'm in a big production facility, and we're distributing produce, and we want to make sure everybody, you know, comes in has a temperature. Or, you know, we're a pharmacy and we want to make sure all of our employees, because we're essential employees, have a temperature check before they come in. Technically, the FLSA doesn't require you to pay for what we call de minimis time, so small amounts of time. And there's been a lot of questions from the business community to get clarity from the Department of Labor during this time period, whether temperature checks is compensable under federal law. And we have not gotten that clarity yet from the Department of Labor, unfortunately. We may get it in the Biden administration, I'm not sure. But I think what we are trying to see is erring on the side of caution is probably the best course here, because not only does it, protect employee morale, it's a best practice, and it probably is not that much of a burden. It could be, depending again on the size of your operations and how many people are tested. We have already started to see some lawsuits that have been filed in California for temperature checks, because California does not have the de minimis rule that the FLSA had. And California also has a unique private attorney general action law that allows employees to file potentially, these are class actions on behalf of all workers, and those kinds of, they're called PAGA claims, can get very costly, very expensive. And so, as I said, we've already started to see some employees and plaintiffs' lawyers start to file those PAGA claims for being tested and not being compensated for that. And then, of course, what happens when we have a vaccine come out? Is that considered compensable time? You may want to encourage, although I don't think you're required to, mandate employees to take a vaccine once it becomes available. The payment for the test is probably not required. The test could be free. It could be covered by insurance. It could be just be made available free by the government. But you could also, again, like these other practices, use as an incentive to pay for the vaccine or the time spent getting the vaccine. It's a similar analysis to COVID testing, although a little bit different, as in COVID testing, oftentimes it might be 24, 36 hours before you get the test results. You may have quarantine for a period of time. So some employers don't want to necessarily have to pay for that. There's no legal requirement to pay for the COVID test or to pay for the time that the person is waiting for a COVID test, other than if you're covered under the FFCRA. But here again, this would just be kind of like a flu shot, right? Oftentimes you come in, sometimes people even bring in a healthcare provider to their office to give everybody in the office a free flu shot. And I think that would be something similar, where it's a short amount of time that the employee is getting the vaccine, and that could be on working time that they are compensated for. Another issue I want to talk about before turning it over to Jordan is, as you start to ramp up your workforce, you may be bringing back your managers before you bring back your hourly employees, because you've got managers that are working, unless you've readjusted their fixed salary during this period of time, you're arguably paying their weekly salary if they work 5 hours or 55 hours. And so a lot of times employers, implement these workplace changes in light of an emergency, and now we're starting to see this happen in a longer period. So you should think about how you're going to handle those managers who are doing non-exempt tasks during the pandemic without risking them converting to a non-exempt employee who'd be eligible for overtime. So you want to think about, again, which workers are exempt, which workers are not exempt, and looking at the broader FLSA exemptions, there are some exemptions to the exemptions in order to allow you to do that. So the question is, will your exempt employees maintain an exemption if they're performing non-exempt duties? Think about this in a restaurant, in a retail setting in particular. You've got a manager who is now maybe cleaning off a bar a little bit more frequently, or stocking shelves, or cleaning off tables. You get in retail, you may be working as a cashier a little bit more frequently, or filling inventory. Those are primarily non-exempt duties. And when an employee spends more than 50% of their time, at least 50% of their time performing exempt duties, you're going to meet the primary duties test of the administrative exemption. However, during an emergency time period, you may have those employees performing tasks that don't appear to satisfy that test, as I just mentioned. And what the courts have said, even before the pandemic, and I think they will continue to apply that going forward, is they're really looking at it as a more holistic approach. It's not like, okay, in this work week, I did 55% of my time managerial duties, whereas the next pay week, I did 45%. They're going to look longer than a work week to make that determination. And they may look over, it could be a month or even longer, really looking at what is reasonable based on the individual. So importantly, what the courts have said is that the time spent performing primary duties is not the sole factor for meeting the duties test. You're going to want to look at the importance of the employee's exempt duties versus the non-exempt duties. How free is that manager from direct supervision, and the relationship between the compensation and the wages that are paid for similar work. And as I said, DOL specifically recognizes that certain managers, particularly in retail or the service industry, do perform exempt and non-exempt work concurrently. And so you are able to potentially have a manager whose a majority of their time is non-exempt will not lose the exempt coverage. And I think, as I said, I think that's going to stay the same over the next, as the pandemic and courts start to evaluate this, as bring back your managers maybe sooner than you would bring back your non-exempt workers. Of course, if you reassign your exempt employee to a different position, and that different position is arguably a non-exempt position, then different analysis would apply. But hopefully this gives you a little bit of freedom and comfort to know that you can allow your managers to do some non-exempt duties without running afoul of risking a misclassification and overtime. So with that, I'm going to turn it over to Jordan to talk about the new Department of Labor regulations in 2020.
Thank you, Kara. Although before I get to my section, there are a few quick questions on your section, and I'm happy to answer them. And then you can chime in if you have anything further based on your portion. But I think, since it's related to your portion, it just might be good to answer them real quickly. And the first question we've got, it says, if you have a telework employee working in a different state than you are based as an organization, or where their original office is, which state law applies? And that's a terrific question. Kara and I have gotten this question, many times over the past 8 months. In terms of employment laws, if you have a telework employee who has moved and is planning and has essentially permanently or for the foreseeable future moved to a different location, that new locations employment laws are the employment laws that should apply for, various leave laws or payment laws or things of that nature. If someone is there temporarily and is planning on moving back, the second the pandemic is over, the second a vaccine is available, then that analysis may change. Each state has promulgated, well, some have not said anything, but some states have promulgated different analyses. And you also have to worry about the tax laws. And again, each state has issued different findings about which tax laws should apply, but kind of the default rule is that the state in which the employee is now living and working is most likely that both the employment law and the tax law that should be followed. But again, that is just a kind of a rule of thumb, and you have to look specifically at the states.
Yeah, I agree. I agree with that analysis as well. And I think in the very beginning of the pandemic, we saw some decisions out from different states that say, hey, if you have an employee who's working here in this state for purposes of the pandemic, that is not a sufficient nexus to our state to allow there to be any kind of tax or other employment related reasons. But now that we're into whatever month we're in, 8 or more, that now employees have relocated and arguably spending more than 50% of their time out of where your original office is. And that has a lot of implications for workers' comp, unemployment comp, payroll tax issues, as Jordan mentioned, as well as employment related issues. It could be that they're in a state where if you have one employee in that state, it's not triggering the employment laws of that state. So what we recommend is that you really require your employees to notify you when they've relocated and what the likely timing is of their relocation. And then from that analysis, do some review of the applicable state employment law and payroll tax related consequences, either for your tax advisors or through legal counsel, to make sure that you're complying. DC, some laws in DC only apply to employees who work more than 50% of their time in DC, but we are still seeing that DC's state agencies are considering, even if your primary office was in DC and that employee normally would work in DC, if they're working in Maryland, arguably DC is still covering them as a DC employee. So it really does vary by state and jurisdiction. And so I'd encourage you to look at that after you've kind of polled your workforce on what their plans are.
And the one other question that we can address before we move forward, Kara just mentioned a minute ago the word workers' compensation, and here's a question asking, how do you deal with the claim that there was a work-related injury while working from home? Either an ergonomics-based injury or a specific injury. And OSHA has not required employers to go to employees' houses, which now could be their work from home stations, to inspect for safety requirements or ergonomics requirements or anything of that nature. However, if an employee does get injured and makes the correlation that it was a work-related injury, certainly as the employer, you should permit and deal with the appropriate paperwork for a workers' compensation claim. I am not a workers' compensation expert, but really this is no different than I believe the law has been the same for years. When an employee works from home and some type of injury occurs, that employee is allowed to seek workers' compensation, as if the employee was on the work site at that time.
Yeah, I agree. And I would also say in your telework policy, it's a good idea to have something in there that, the employee acknowledges that they will find a safe place to set up their office that is free of hazards, electrical or otherwise, and that they will, have a desk and a chair and do as best as they can. this also certainly leads into a whole host of other issues, not necessarily wage and hour related, but I could see getting a lot more requests for accommodations for stand-up desks at home or certain types of chairs. So, as we navigate those unique ADA accommodation issues, that sort of stems from the work from home issue. But I agree with Jordan, while there's not going to be any OSHA related inspections for a work from home office, if someone is injured, it likely is still considered a workers' comp claim.
And just to dovetail back to what Kara was saying about 15 minutes ago, whereas you might not have a legal, FLSA or wage and hour obligation to pay for or reimburse employees for their home office, for stand desks, for ergonomic chairs, proactively doing so while not required may potentially, help to prevent ADA type reasonable accommodation claims in the future. So, as Kara said, it's something to consider, just as a way not only to be let's say a good citizen employer, but also to protect your bottom line and protect against liability. With that said, to further increase that theme of decreasing potential employer liability, let's talk about a few of the new 2020 DOL regulations. January seems such a long time ago, so I do not blame any of you if some of you have, some of these 2020 DOL regulations that were promulgated before the pandemic, if that's not top of mind, that's understandable. But, we need to make sure that everything you're doing is following these laws, and failure to do so could result in significant liability. So the first kind of new law that I wanted to remind you all of, and it's not really a new law, it's a new clarification of an old rule, it is the rule dealing with the employee's regular rate of pay. Hopefully, you all know on this call that an employee's regular rate of pay isn't just their hourly rate. It is their hourly rate plus any other compensation that that employee receives for admin work, for other non-discretionary bonuses or commissions, or any other earnings should be factored into an employee's regular rate of pay for overtime. And this has caused a lot of confusion over the years. So as a result, in January of this year, the DOL updated the regulations governing the regular rate requirements under the FLSA. It was the first time in over 50 years that this was updated. And before this update, left a lot of employers uncertain about the roles that perks and benefits play when calculating the rate of pay. I like to refer to these new regs as the no good deed goes unpunished regulations, because in the past, employers would provide Christmas bonuses or provide incentive bonuses, and then Kara and I would have to advise you that, there's a chance you have to include this in the regular rate of pay, and all of a sudden the employee's overtime calculations went way up, or you ran the risk of potentially getting a wage claim because you gave someone a holiday bonus. So I just wanted to make sure that you all knew now that the DOL has clarified regulations to confirm that employers may exclude a whole host of discretionary type earnings from the regular rate of pay definition. And just some examples of that are parking benefits and wellness programs and gym access. Again, these are now excluded from the employee's regular rate of pay. Arguably, they were excluded beforehand, but there was no actual language that said so. Payments for unused paid leave, paid sick leave is excluded. Reimbursement Kara talked about reimbursement before, but reimbursement expenses for cell phone plans, for internet now that employees working from home, excluded from regular rate of pay. Certain sign-on bonuses and longevity bonuses are also excluded, and coffee and snacks to employees as gifts. So essentially things that are discretionary, although just labeling them as discretionary doesn't exactly suffice. They actually have to be discretionary, and that all would be excluded from the employee's regular rate of pay. Keep in mind though, non-discretionary earnings, productivity bonuses, commissions that are actually defined, and things of that nature still would be included in the regular rate of pay. And then that dovetails to the next related topic I want to talk about, which is the calculation of overtime rate. As Kara mentioned, some employees now will be working dual jobs, and she talked about the exempt and non-exempt status of those employees. For me, I will say these employees are non-exempt and they're working two different jobs. And again, as an employer, you're trying to sustain business operations and reduce costs during this pandemic. And you may be asking employees, especially if others are furloughed, to perform work in these two separate positions. And most likely, the separate positions have different rates of pay. Over the years, I can't tell you how many calls I get from employers who have struggled to determine what the rate of pay should be for the employee who works, two different rates for overtime. One easy answer, which you probably don't want to do, but just so you know you can do, you can always pay overtime on the highest rate of pay that the employee worked during the week. Of course, that would cost you more, but at least that reduces the logistical difficulties and administrative burdens. But assuming you don't just want to spend unnecessary money, which is most of my clients, you must calculate the blended rate every week for each employee, and it's the weighted average of the different rates of pay that the employee worked during that week. I have a note here on the slide. The blended rate should not be reflected as the employee's hourly rate for all worked on any pay stub. Rather, the hours worked in each task at each of the assigned rates should correlate, but then you just blend the rate when you're paying the employee for overtime and calculating the overtime rate. There shouldn't be any analysis that the blended rate is actually this employee's hourly wage. It is just the regular rate of pay for overtime. And I know, without talking specifics, it's tough to give a general analysis of this. When I deal with employees, we have to get our calculators out and, multiply 1.5 times each of those rates. So if you have any specific questions about this, we can handle that going forward. But just keep this in mind during this time when employees are likely working in different rates. Now to move on to a different subject, I have given presentations over the years regarding this joint employer rule. And I'm not sure if I've ever given a presentation when that rule was not in flux. And as luck would have it, that continues to be the case now. Right around the time of the pandemic, actually, mid-March, March 16th, the DOL actually issued a final rule revising joint employer status under the FLSA. And although the joint employer rule has changed over the years, that's been often in the National Labor Relations Act context. The FLSA hadn't actually updated the joint employer rule in over 50 years. So the DOL decided, you know what, we're going to make the first substantive change in a long time, and we're going to provide new framework for assessing joint employer status when an employee performs work for an employer which simultaneously benefits another individual or entity. They call this the vertical employment situation. So an employee who works for a subcontractor, and then that subcontractor subcontracts that employee out to another entity where that employee then performs work. And so the DOL applied a 4-factor balancing test to assess whether the third party, the ultimate employer, whether that party who benefits from the work of another company's employee should then be considered a joint employer. And I'll go through the 4-factor test in a minute, but I'm going to point this out here, this last bullet point, and keep this in mind. The DOL said the economic, whether the employee is economically dependent on the potential joint employer was not relevant for determining joint employer status. So the economic dependence was not deemed to be relevant. Keep that in mind. The 4 factors that the DOL did find to be relevant were whether the employer hired or fired the employee, substantially supervised and controlled the employee's work schedule, determined the employee's rate of pay, and maintained the employee's employment record. The DOL thought that with the adoption of this test, it would bring more certainty and clarity as to which types of business arrangements would be considered joint employment. And note that the bullet point here says this would narrow the previous interpretation. Under the Obama administration, it had been, this rule, again, while it wasn't a revision to the FLSA, it had been analyzed differently. And number 1, 2, 3, and 4, you would all put the word ability to in front of the sentence. So if an employer just had the ability to hire or fire an employee, or the ability to substantially supervise the employee's work schedule, or the ability to determine the rate of pay, that entity would be considered the joint employer. This rule deleted that ability to language and actually made the control be actual, not theoretical. And as you can see, from this next slide, because of that, the actual control, the employee and the dichotomy between whether you have the ability to control or whether you actually control, there was a chance for that an increased number of employees could be subject to, or could subject employers to additional employment laws. That is the crux of the joint employer context. Employers don't want to be considered a joint employer because then they're subject to more employment rules, specifically wage and hour rules under the FLSA. But if you're also considered the employer, you might be subject to the FMLA's requirements, which you wouldn't if you were just a subcontracting entity. And this last bullet point, for lack of a better word, I have here is the rule is not binding on the courts. And then that leads us to this next slide, which over the summer, a coalition of state attorney generals sued. They claimed that this rule, unfortunately for employees, weakened the critical workplace protections that I was referencing on the previous slide. That they said now employees wouldn't be protected and wouldn't be able to bring applicable wage and hour claims for any potential violations of the FLSA. And the case went to the Southern District of New York, and in September, Judge Gregory Woods for the Southern District of New York stated that the DOL's rule had major flaws and that it did not comport with the FLSA. He also found that the DOL did not follow the appropriate rulemaking process. Rather, he held that the proper test is the economic realties test. So remember a few minutes ago, I said to keep in mind that the DOL said that the economic dependence was not deemed to be relevant. Now this judge for the Southern District of New York says economic dependence is extremely relevant. And if you as an employee are in essence economically dependent on either of these employers, they should both be considered joint employers. And this dovetails into the independent contractor test that I will get to in a minute. So this ruling really diminished, the bulk of the DOL's rule. Not all of the DOL's rule, but the significant majority of this vertical employment portion of the DOL's rule. But just last week, in the midst of everything else going on in this country, on Friday, the DOL actually appealed this decision to the Second Circuit, saying that the striking down of this rule would be absolutely detrimental to small businesses who should not be deemed to be joint employers, and this rule really inadvertently makes too many employers joint employers. So the Second Circuit will now be hearing oral arguments, in the next few months, and a potentially final rule will then be promulgated. Of course, assuming the Biden administration gets into office, they also may have some say on the final rule, although they wouldn't have the power to overrule, at least immediately, whatever ruling the Second Circuit comes up with. So that's a very quick summary of the joint employer rule. Sometimes we can spend a full hour talking about that, but I just wanted you all to be aware of the current state of the law, which again is every week seems to be changing. So now we just really have to keep our eyes and ears open to see what the Second Circuit decides. As I said, that kind of dovetails into independent contractor classification. And I don't want to spend too much time on this because, again, a Biden administration could potentially seek to impose tougher classification standards through the regulatory process than these current independent contractor standards. But just about less than 2 months ago, the DOL did propose new regulations in a rulemaking process to help determine whether an individual is an employee or a contractor. And this economic reality test is one of those tests, similar to the new joint employer test. And there are 5 key factors to analyze. And if you see from the next slide, as has been the case for a long time, the main point, the main thing you want to analyze in the independent/employee test, the independent contractor/employee test, is the nature and degree of the individual's control over the work. If an employer is setting the employee's schedule, selecting the projects, telling the individual what to do, the individual is likely an employee. But if the individual has substantial control over his or her schedule or workload, then that individual is more likely an independent contractor. I put a little caveat here. Even though if a company requires an individual to comply with specific legal obligations, that does not necessarily mean control. That is just complying with the law. And an individual can still be found to be an independent contractor, even though the company is making that individual comply with specific legal obligations. The second biggest factor, the core factor, is an individual's ability to earn profits or incur losses based on their own initiative. The greater an individual can do that, the more likely the individual is considered an independent contractor. And the other 3 factors that you can see on this next slide are extremely important, but under this new rule, not quite as important as those first two core factors. And those three factors, as you can see, are the amount of skill or specialized training required for the work, which the company does not provide. The more skill, it leans towards independent contractor status. The less skill, it leads towards employee status. Two, I always think this one is pretty determinative, and that is the degree of permanence of the working relationship between the individual and the company. The more permanent, the more likely it's an employee. The less permanent, the more likely it's an independent contractor. And finally, whether the work can be separated from the possible employer's production process. And if it cannot, it is more likely the individual would be considered an employee because he would just be doing what all the other employees are doing and not offering separate services. The last thing I want to talk about before handing over to Kara and just going over some of these issues and how they relate to the potential Biden administration is the new overtime rule. And hopefully all of you guys were aware of this in January, but again, with so much that has happened, it's possible some of you may forget that the threshold standard for an employee to be considered exempt was increased in January. It was not increased to as much as the proposal, 3-4 years ago that former President Obama had initially proposed. I believe that was supposed to be 45,000 or so, but the standard threshold is now 35,568. So if an individual makes less than that, but more than 26,000, which was the previous amount, the individual must be considered a non-exempt employee, and you do not even have to look at the duties that the employee performs. So again, if an employee makes $35,000 flat, that employee should be considered a non-exempt employee. Note that there's also the overtime rule also raised the threshold for highly compensated employees and has a few other caveats that I'm not going to get into the weeds now. But note that for that 35,568 level that I just referenced, different states may have different levels. In particular, I believe New York, California, and Maine have a higher level than that amount. So that is very important to keep in mind if you have employees in those three states, to not just rely on this federal number. But obviously the implications of this new rule are an increased amount of employees, supposedly over 1.5 million are now eligible for overtime. So as an employer, you'll have increased pay, overtime pay for employees, and so you want to also evaluate and reclassify your employee positions to see who may or may not be eligible for overtime, taking into account the duties that those employees perform. And you may want to reconsider policies regulating overtime and overtime tracking systems, especially with the increased, working from home, because increased work from home, as Kara mentioned in the beginning, may lead to employee miscalculation of hours work, which could increase overtime claims, especially now with this, this new threshold. So you just want to be aware of the significant potential increased cost of this, and as a result, possibly continue to evaluate the classifications of your current workforce to reduce that cost and to ensure you're meeting the current requirements for all of those white collar exceptions, which again, I'm not going to get into the weeds and talk about now because this new test did not necessarily impact those white collar exceptions. But you still need to be aware of them in light of this new increased overtime threshold amount. So that is just, if you haven't done an audit in a while, this would be a good time to make sure at least all your pay practices or your pay classifications and exempt non-classifications are correct, given that you will need to change some of these classifications if you haven't already done so. And with that, the last few minutes, Kara will talk a little bit more about these issues specifically under a potential Biden administration.
Okay, thanks, Jordan. So yeah, just really quickly, won't spend too much time about this, but in the extent that there may be a change in the administration, there's definitely going to be changes to the Department of Labor. Many of you know the current federal minimum wage is $7.25 an hour. That's been unchanged since July of 2009. Most states, however, are much higher, although not in Virginia. It will start to go up in May of 2020. So many of you in other states in other parts of the country may already see minimum wage much higher than $7.25. And of course, it goes without saying that your non-exempt employees have to receive an overtime premium of time and a half times the regular rate of pay, as Jordan discussed, for all hours worked in excess of 40 under the federal law. We may see under Biden is that he will try and likely increase the federal minimum wage to $15 an hour. That probably needs Senate approval. And right now, the Senate is up for grabs. We're not sure how the runoff election is going to go. But if Republicans maintain the Senate, we might not see that get through. But Biden could issue executive orders, and he has said, even in just the last few days, that he would be doing so on a whole host of issues and apply this to federal contracts. So if any of you are federal contractors and have a lower hourly rate, just be mindful that this could be coming down the pike for you in the next year or so. He also has stated that he wants to index the minimum wage to the median hourly wage. That was an issue that was discussed during the overtime rule, and a lot of employers in the business community strongly opposed that. He's discussed supporting eliminating the tip credit. So tip credit doesn't apply on the West Coast, but for the most of the rest of the country, if you are in hospitality and provide, the service industry and provide tipped workers, you're able to take advantage of a tip credit, and that could be revised or eliminated. And then it's also possible that, as Jordan just mentioned, the new overtime rule came into effect in January. That did not go as far as was requested in the Obama Department of Labor. Under those proposed rules, it was going to be even a higher salary level to qualify for exempt status, and even contemplating altering the duties test. So that could be another issue that comes out on the table. Jordan talked about independent contractor classification. I think it's no surprise that Biden administration will want to broaden the definition of employee. And so constantly in this flux situation, going back and forth, where there's this standard model on the ABC tests for labor and employment and tax laws, very similar to what was discussed by that New York court, the economic realities test. And so I would imagine, as Jordan opined, that even if that case gets appealed, we might see a change from a Biden Department of Labor. Definitely that would result in fewer workers meeting the independent contractor definition and change, the current DOL rulemaking. We saw increased efforts of enforcement of misclassification of contractors during the Obama administration. I think it's fair to say we could see something similar under a Biden Department of Labor. The last thing I want to mention before we open it up for questions is the idea of predictive scheduling. Many of you, probably particularly in the retail and service industries across the country, may have seen state and local legislation with respect to predictive scheduling. But Vice President-elect Harris has co-sponsored legislation called the Schedules That Work Act at the federal level, which would require employees to request changes to their work schedules without fear that they would be, there would be an attendance issue or they wouldn't be able to change that, and require employers to provide, predictable and stable schedules in certain occupations. That also sometimes allows for a minimum amount of notice between scheduled shifts. And the argument there is, particularly, like I said, in retail and service, people need to have stability so that if they have childcare, they can establish that. If they have other needs, that they're able to have a stable schedule so that they're able to accommodate their private life work rather than having coming into work different days at different hours. So we'll see some of those state and local legislations are subject to legal challenge currently, and we'll see how that goes. But we're getting right to the end of the hour, so I wanted to make sure that you know about our blog. If those of you are familiar with us, we know we try and post regularly to our blog, so please sign up for that. We have one more webinar, the last webinar of the series, which is called Delaying Retirement, the Impact of America's Aging Workforce, on December 16th. So please register for that if that's a topic of interest. And then Jordan and I will be happy to answer any questions. We'll look through, see what's coming in the chat. And if anyone else has some questions, we'd be happy to take them at this point.
Yeah, Kara, I can start. We don't want to go too far over, but there's a few questions that I can read and we can answer quickly. The first one I see is, can an employer require an employee to come into the office if the employee raises ergonomic issues working from home? And the short answer I have is yes. At this point, unlike in March and April and even May, that there aren't stay-at-home orders issued by a state, and an employer can always require an employee to come from home to work from home if they think for whatever reason it's better for their business, or if it's better for the employee's health. Of course, if the employee has some sort of disability or some sort of high risk, then you get into some of those factors. But simply requiring an employee to come into the office at this juncture, again, this could all change anytime, but at this juncture, I don't see any problem with that. The next question was, when I was talking about the regular rate of pay law, and an individual has asked, what about mileage reimbursement or gift cards? So long as those are discretionary, they would fall into the new law that those are excluded from the employee's regular rate of pay. So they should not impact an employee's regular rate of pay. A cash bonus, as you point out in your question, that could be different. But mileage reimbursement or a gift card that is a discretionary gift card, for a holiday or for a birthday or something, that's kind of the point of the rule. The way I phrase it, the no good deed goes unpunished rule. So I think that should be okay. And as for the 4-factor test, right now, although I spent a few minutes on that 4-factor test, right now, until we hear from the Second Circuit, that 4-factor test for joint employer status is not necessarily the law. So you do not have to worry about that right now. However, you need to be aware, you probably want to be more cautious, because it's potentially, it's possible even the ability to control an employee's work could be found to implicate your status as a joint employer. And yes, both of you have to comply with the laws, which is why, and it is logistically difficult, as it seems like you're asking from your question. Let's say the staffing company is the one that's responsible for payment. You need to talk to your staffing company and make sure they're paying accurately. And you might want to have something in your contract that, it indemnifies you for any mistakes that they make, because under this joint employer doctrine, you are jointly and severably liable for potential pay issues. That is the exact reason why it's such a big issue, and it's, you know, such a hot button issue that we always talk about. It really increases your potential liability. And the last question, yeah, I was actually going to mention this if we had more time. You know, the question is, do you expect Biden to pass a law making gig economy workers employees? And, you know, would that override California Prop 22? And it's certainly possible, and I might say even probable, that, you know, Obama, a big portion of his agenda was something called the independent contractor / worker misclassification initiative. So Biden may continue that, and yes, if he makes a law that you know, if Congress passes a law that says, for example, all Uber drivers are employees, that would override what California has right now, which, you know, just is the mandate right now of the electorate that those individuals are employees. But, you know, that it's possible if Biden makes that law, it could be challenged. There could be court cases. We probably won't get a clear answer on this gig economy worker / independent contractor issue for quite a while.
Okay, great, Jordan. Thanks for handling those questions. It doesn't look like we have any others, but if anyone thinks of any after today's call, don't hesitate to reach out to either Jordan or I. Thank you for joining us today. We hope you found this information to be practical and helpful as you go back to your workplaces, and happy to answer any questions following the call. Thanks, everybody. Bye-bye.